Welcome to Property Power Talks, the exclusive podcast for NB Property Law. I'm your host, Kayleigh Swift, and each episode will dive into cutting-edge insights on property law, probate, estate planning strategies, and seamless estate administration. Whether you're a property investor, homeowner, industry professional, planning your estate, or wanting to understand how estate administrations work, then our expert discussions will empower you with the knowledge you need to navigate the complexities of property and estate planning law with confidence. Let's unlock the power of property and estate planning law together. Good morning, everyone. Thank you for joining us today. So, as most of you probably know, my name is Kayleigh Swift. I'm the director here at NB Property Law. Today, we're obviously here to talk about the Queensland residential contract amendments that have come into play in terms of both tenancy laws and also the new Queensland Property Law Act that has been passed through Parliament, but we're just waiting for an actual commencement date, which is expected within the next 6 months, according to some of the experts. So our agenda for today, so as I mentioned, we're going to talk about the amendments to the residential tenancy laws first and what changes this is basically brought about to the standard residential purchase and sale contracts. Mainly we were talking about the REIQ contracts. So as some of you may know, the REIQ contract is probably the most commonly one used in Queensland. I'd say probably about 80% of contracts we see come across our desk are REIQ contracts. And then there is another form of contract called the ADL form, which probably makes up maybe about 15%. And then the other 5% sometimes are just other contracts that are drafted specifically for certain transactions. We'll also go through the new Property Law Act that was passed through Parliament in 2023 and what that's going to entail in terms of the seller disclosure changes, again talking about residential standard sale matters in Queensland. I'll go through briefly about the general provisions of standard residential contracts. A big one we're seeing currently is in terms of electronic signing. What is the actual contract date? Often the contract date is not actually stipulated at the top of the contract where the spot is there for it, but there is signing records showing the electronic signatures. So we'll go through that. We'll talk about settlement extensions and how they can be applied for or granted with residential sales and purchases, and also deposit amounts. So often we have clients that come to us, whether it be even a buyer or seller, that are unsure what a deposit is meant to be in a standard purchase, and then we'll have some time at the end for any questions and answers. So what we're all about here at NB Property Law, so we like to think that we offer a personalised, proactive advice to minimise risks and take the stress out of your next property transaction or estate planning matter. So we're more than just a team of legal experts. We're dedicated problem solvers committed to creating personalised solutions to guide you forward. Whether it be from residential to commercial property law concerns, we are here to provide the clarity and guidance that you as clients need throughout the legal transaction. So obviously I'm NB Property Law. We also have other 3 divisions here at NB Law Group, NB Migration Law, NB Employment Law and NB Commercial Law as well, our other teams. So as I mentioned, we're going to start off first with the changes that have come into place in Queensland and what that's meant in terms of tenancy laws for our contracts. So now, as of this is all quite new, as of the 6th of June 2024, a seller is required to disclose if the property has been subject to a residential tenancy agreement or a rooming accommodation agreement at any time during the 12 months prior to the contract date. Now, the contract date is the date that the seller actually signs the contract. So if the property has been rented out any time during the 12 months prior to the contract date, the seller must provide details on when the last rent increase was. And from the 6th of June, that rent cannot be increased more than once during a 12-month period. So the 12-month minimum period continues to apply if there is a change to the rental property manager, owner or tenant. So that means even if you are selling a property that has a tenancy agreement in place, a new buyer owns it, maybe the seller was renting it to, brother or sister quite cheaply, and they've already increased that rent, although it's still, below market value, that cannot be then increased still until that 12-month period has expired. So it's important for both sellers making sure they're disclosing that, but also buyers, beware. You know, they're entering into these contracts and they need to be aware that they're locked into that 12-month period then from when the last rental increase took place. Now, the amendments to these tenancy laws. So at settlement, the seller must provide evidence of the last rent increase, as the tenant can require the landlord to provide this under the new amended contract. So this is now an essential term, and if the seller does not provide this evidence, the buyer will have the right to terminate the contract. So this does not apply to holiday or short-term letting. You know, things like Airbnbs and things like that won't be included in this. So the landlord must provide details of the rent increase within 14 days of the tenant's request for this information, which is why it's now formed part of the contract. However, the requirements to provide evidence of a rent increase does not apply if the premises were purchased within 12 months of the tenancy agreement and the property manager or owner does not have the information about the date of the last increase. So this requirement also does not apply to exempt property managers, owners, or exempt providers, which, you know, as I mentioned before, you know, exempt owners may be ones that are doing the short-term holiday letting. And for whatever reason, if they didn't get that information at settlement, for some reason it was not available, that liability won't fall on them in terms of providing the information to the tenant within those 14 days. Now, what warranties have been included in these REIQ contracts regarding the tenancy? So the seller warrants that the statements made in the contract in relation to the tenancy are true and correct. If a previous version of the contract or a non-REIQ contract is being used after the commencement of these changes, which come into place on the 6th of June 2024, then consideration should be had to incorporating similar obligations on the seller. So if the contract is already signed, as a buyer, you might consider whether clause 8.42 under the REIQ contract may be used to request information about the last day the rent was increased as a document necessary to manage the tenancy. So under that clause, it allows the buyer to request information pertinent to the sale. So, you know, that clause can be used to request information about the tenancy if for whatever reason an old REIQ contract is being used that doesn't have these updated tenancy law provisions within it. So there are warranties that are now being placed on the sellers to make sure that they're providing accurate information to buyers. And I suppose from an agent's perspective, they need to be making sure that the contract's completed to properly stipulate what the situation is with residential tenancy agreements and whether any are in place, and if they are, you know, has rent increased within that last 12 months and, you know, the date of that. From buyers, you know, they're going to be wanting to check copies of the actual tenancy agreement. Also a good idea to be checking the actual tenancy ledger, making sure, you know, the tenant has been paying on time, they're not in breach or anything like that, and the information that is included in the contract accurately reflects what's in those tenancy agreements and the tenant ledger. Now, we're going to move on to the actual contract date. So, as I mentioned before, if the parties sign the contract electronically, but the date is not inserted on the contract date will be the date that the last party signed. We still need to work out what that date is though. So, for example, what happens if the person signing is in a different time zone? If this is the case, which happens, you know, very commonly, you know, you've got people that are in, you know, even just different states, so sometimes different time zones, overseas, whatever it may be. The date though is taken as the date it was signed in the time zone that settlement will occur. So generally that's always, we're signing REIQ contracts, which means it's a Queensland property, so the time zone of Queensland will apply in that situation. Now, if the parties, oh sorry, I moved on too fast for you. If the parties have signed the contract, you know, and it's done electronically through things such as DocuSign and other similar electronic signing tools, but they can rely both parties can rely on that actual date and timestamp that's been included to determine what the contract date is. Even though there may not be a contract date right at the top of the contract where it's normally handwritten or typed in, that date stamp that's on the DocuSign record or whatever electronic signing record it is enough and sufficient for both parties to rely on. Obviously, it still does arise where that record is not included with the contract, or parties just for whatever reason have signed and there just isn't a date included at all, and that just becomes just an extra process where the solicitors for both sides will just need to ascertain what the date the last party signed. Generally, the last party signing the contract is often the actual buyer, the seller. So the buyer will sign first and the seller is generally the last person to sign. So it's just a matter of the seller's solicitor checking, as to see what date and time it was that they actually signed, and then can be agreed between the parties to, hand amend the contract to include that date in there. The contract date's obviously a very important date because essentially that's the date that all the conditions commence from. So, settlement might be, for example, 30 days from the contract date, or deposit might be payable, the initial one on the contract date, and finance and things like that. So we do need to make sure that date is ascertained early in the process so we can calculate what those critical dates are. So I'm going to move on now to another one. I think it's probably the most major change that we've seen for property law in Queensland in quite a number of years, and that's the New Property Law Act that's basically repealed the current 1974 legislation. So, as that date shows you, like it is, it was quite outdated, almost, 50-year-old legislation we're talking about that's now being overtaken by this New Property Law Act. So this bill did receive royal assent in November 2023, but we still don't as yet have a commencement date. As I mentioned at the start, the current indications suggest that it will be in the next 6 months. However, that's still just an estimate. We don't have an actual clear date set in stone, and we won't know that, until it comes about. So as soon as we know, we'll do an update, we'll do an article and let our clients and referral partners and things know, and post on our social media. So feel free to follow us or subscribe to our newsletter, and we're happy to keep you updated on that one, or give us a call or email, and we'll update you with any information that we know. So the major changes though that are going to affect residential sales are in terms of a statutory seller disclosure. So the sellers will be required to provide a disclosure statement to prospective buyers. So this is very similar to the southern states. They have had these provisions for quite some time. Queensland, I think is catching up a little bit here and going to have a similar regime put into place. There's also going to be changes to the parties' rights if the property is destroyed or unfit for occupation, and also updates to the settlement date and rights to extend settlement to align with the current REIQ contract rights. So as I mentioned though, the date will commence is to be fixed by proclamation, meaning a date that was going to be set by Parliament in the future. Unfortunately, we don't know this date yet, but obviously we're hoping soon. Obviously, we know there is a state election coming up, so maybe once a change in government, or whether it remains the same government, that may also help dictate as to when that will be. Government seems to take a bit of a holding pattern over election period, where not much gets done in the lead up to election. So we're hoping, shortly after election is over, that we will have that date for proclamation set. Now, the seller disclosure. So the biggest change is the mandatory seller disclosure, which I mentioned before, which will be required for the sale of all freehold properties, including units, and there are exemptions though to this one. So those exemptions will be sales between related parties, sales between co-owners or neighbouring landowners for a boundary realignment, if it's a court-ordered sale, if it's a transfer to a personal representative or a beneficiary, so often in estate planning matters, where the sale arises from the option and the seller has previously provided the disclosure to the buyer, this exemption does not apply if there is a nominee. So that's like often when you're doing like put and call option agreements. It will also be exempt though where the sale price is greater than $10 million including GST and the buyer just waives that requirement. The disclosure will be exempt where the seller is a local government and the sale is to recover overdue rates and the buyer is given notice that the seller is not required to provide disclosure. Another example of the exemption will be where the seller is the state government and the buyer has been a tenant of the property for at least 3 years. And the last exemption will be where the buyer is a publicly listed corporation. Okay, now the seller disclosure will be in addition to the current disclosure requirement. So obviously already there's stipulations in the contract that seller has to disclose certain things. You know, one of them, for example, was what we mentioned before in terms of the new tenancy laws. Obviously, when sellers are selling a property that's part of a body corporate, there's already a body corporate disclosure statement that goes along with those contracts. Now, real estate agents will be permitted to prepare and provide the disclosure statements on behalf of the seller. Obviously, for real estate agents, obviously, you know, there's a risk there. They need to be getting proper, clear, accurate, and true and correct instructions from the seller so that that document is prepared correctly, because you know there's a lot of things that are being disclosed by the seller, even though it may be done on behalf of the agent. Now, the disclosure documents can be prepared and provided electronically, the same as what the contracts can at this stage. We would expect, you know, part of the delay may be with the, you know, new laws coming into play, is that the government's obviously probably looking to develop a form to help with that disclosure statement. At this stage, again, we don't know any information about what that form looks like, but we would expect to see something like that as well when the laws come into play. Now, what actually needs to be disclosed? So, you know, there's a range of different things. Obviously, the actual property title, any planning and zoning statuses, any building works or details of any works that have been done by any unlicensed person. So, you know, builders for whatever reason, you know, or maybe just home handymans. Any infrastructure proposals, what the actual amount of rates and water accounts are, body corporate information certificate, which is an important one because often at the moment that's something that sellers are often having to pay for themselves. So this will fall then on, sorry, buyers have to pay for, so this will fall on the seller's obligations then. The community management statement and any additional bylaws not included in that community management statement. So this is often to do, or it is, community management statement is to do with body corporate or strata property. So any property that's, you know, an apartment or townhouse or anything the like. And bylaws are just like the rules of that body corporate. Any environmental issues, and for commercial buildings, details on whether there is a building energy efficiency certificate available. Now, unlike other Australian jurisdictions, Queensland has traditionally operated on a caveat emptor principle, meaning buyer beware, where the buyer bears the responsibility of due diligence on the property they are looking to purchase. So under this new seller disclosure scheme, the seller is obligated to provide a signed disclosure statement in an approved form. As I mentioned, that will be, you know, the government will come up with what that form is. We just haven't seen a draft of that as yet. And it will contain certain prescribed certificates to the buyer before the buyer actually signs the contract, either electronically, as I mentioned before, or obviously it still can be done physically. Now, the statutory requirements includes information, as I've just mentioned here and included on the slide, but the need to disclose applies to the sale of all freehold land, including auctions. However, there are exemptions which we went through before. So when and how will the disclosure documents actually need to be given? So the disclosure documents will need to be given by the seller to the buyer before the buyer signs the contract for the purchase of the relevant lot, you know, which is quite similar to the disclosure statements given with body corporate properties at the moment. So the disclosure scheme allows the seller to provide the disclosure documents to the buyer either physically or electronically, as I mentioned before. This is an expected but welcome feature given the shift towards, you know, our e-conveyancing and, you know, settlements and things on PEXA. That all become mandatory for us recently, and obviously now, this is the next step in changes with property law. So I suppose then the question comes about what happens if, I as a seller, or maybe it's even the agent, do not comply with the statutory disclosure scheme. So the seller disclosure scheme gives the buyer the right to terminate the contract for sale at any time before settlement. All right, so it is a big issue if the seller fails to provide any of the disclosure documents at the relevant time or provides the disclosure documents that are inaccurate or incomplete regarding a material matter. So it is very risky if the seller, is not providing the information at all, or for whatever reason is providing information that's incorrect and not accurate. So what does not need to be disclosed then by the seller? So they're still not under any obligation to provide flooding history, although as many people know, there are flood mapping reports and things that local governments do provide. So, buyers can still go and get access to this information, but it's up to them to do that during their own due diligence period for a property. They're not required to disclose things about structural soundness of the building or anything to do with pest infestation. They don't need to provide any current or historical uses of the property, and they don't need to give any current or past building approvals that they may have sought during the time that they've owned the property. There are limits imposed by planning laws on the use of the land, and also the services that may or may not be connected to the property do not need to be disclosed. So at this stage, unfortunately, the bill does not allow for structural disclosure. It allows for further disclosure of other information that a seller has to disclose, but it doesn't bring it in line entirely with what the southern states are. So we are still a little bit behind the 8 ball there. With purchases, I would recommend for clients, obviously they're not required to give, details of building approvals and things like that, but it's always a good idea to, make sure they're looking as to whether a condition should be a special condition included in the contract still regarding structural engineers' reports. So if that comes back adversely, that would allow them then the option to terminate the contract and receive back any deposit they've paid, or they could negotiate with the seller to fix these issues prior to settlement. There could be even a reduction in the cost, which could allow for that, and the buyer can deal with it post-settlement. So, there's structural soundness, if it's not being disclosed, a normal buyer is not going to be aware of that, and potentially even their building and pest inspector is not something they're going to pick up. It is really something that a structural engineer needs to be, checking and providing a report on. So it does need to have an actual special condition to deal with this. The other thing is failure to disclose will give the buyer the right to terminate the contract, as I mentioned before. So it is likely that search providers and local authorities will offer kind of like a bundle search similar to what the other eastern states do, where sellers can just automatically download this information to properly do up the disclosure they need to provide to buyers. If the seller does provide disclosure, but the documents are incomplete or inaccurate in relation to a material matter, then as I mentioned before, the buyer can terminate the contract, and if they would not have signed the contract had they known the correct information in the first place. So there are big ramifications for the seller not disclosing and disclosing information that's inaccurate for the buyer to rely on. So categories of sales that are excluded from the statutory seller disclosure scheme. So these are the following categories that won't be listed. Now, I did kind of go through these before in terms of, whether it's a sale between related parties, if it's a co-owners or neighbouring landowners joint boundary alignment, any court-ordered sales, also any transfers, as I mentioned, in estate planning matters that are transferring it to a personal representative or an actual beneficiary under the will. Also contracts that arise out of put and call options, and if the sale price is greater than that $10 million mark and the buyer actually agrees to waive the requirement, or if the sale is where the seller is actually local government and the sale is to recover overdue rates or charges, which happens from time to time. And lastly, as mentioned previously, where the seller is the actual state government and the buyer has been a tenant of that property for at least 3 years. So the Act is basically much needed modernisation, I see, of the Property Law Act, which should lead to simpler and more streamlined property law regime in Queensland. So although the Act retains the majority of the well-established property law principles, there are still some significant changes to the existing law that stakeholders such as real estate agents should be aware of. All right, that's kind of it on the seller disclosure and talking about the Property Law Act from a residential point of view. Now going to move on to the actual settlement date. So that's another very important date, obviously, of any purchase sale contract. This time will not be of the essence for adverse events. So this means that in an adverse event, the party affected by the adverse event can delay settlement until they provide notice that they are no longer affected. Now, what is an adverse event? So it includes a range of different things, whether it be cyclone, fire, flood, landslide, you know, a storm, tsunami, tornado, whatever it is. We know, you know, Queensland, unfortunately, we do suffer some of these things. Obviously, others, touch wood, not as much as you know, floods and things like that. Also, an adverse event could be, you know, public health emergencies under the Public Health Act, and the requirements to comply with a lawful direction or order given by a government entity under a law or commonwealth of the state, or any act of terrorism, activity related to war, civil commotion, public disturbance, or riot. And lastly, an adverse event could also include an explosion or sudden impact of an object, for example, an aircraft or object from space. So this is similar to the current clause 6.3 of the REOQ contract, dealing with these adverse events and how they could delay settlement. Now, what are the rights to actually extend settlement then? So previously, if a party was unable to settle on the due date, they would be in breach of the contract, and, you know, contract could be terminated, seller could lose the deposit they've paid, and the buyer could then walk away from the transaction with the deposit and go and find a new buyer. Now, this meant that even if the delay was outside of the party's control, for example, the most common one we see is where the buyer's bank is not ready or not arriving at settlement on time. So the contract could be terminated by the other party. Now, the standard contract has thankfully been updated it's probably been about 2 years now, to include the right to extend settlement by up to 5 business days without penalty. Now, for this to occur, all that's needed is written notice must be provided by either party. So either the seller or the buyer can automatically now extend settlement by 5 business days, as long as they do so by no later than 4 p.m. on the settlement date. Okay, so this settlement extension can also be requested outside of what is that standard clause 6.3 of the REOQ contract, which just automatically allows both parties to extend. I suppose with that clause, if parties are extending out of that clause, the thing to note is it doesn't have to just be one extension of 5 business days either. It can be multiple extensions that add up to 5 business days. So a seller or buyer could extend, you know, 1 day each day, and note each party have 5 business days. So if in some situations, it could be a seller extending by 5 business days, but a buyer could then extend by a further 5 business days. It's just 5 business days for one per party, essentially, per seller, which is one entity, and per buyer. Now, to do so outside of that standard clause 6.3, both parties, as I mentioned, have to agree. For sellers, they can choose to impose penalty interest, though, should they wish to do so. Now, if they do choose to impose penalty interest, it's generally what's known as the Queensland Law Society default contract rate, and if the buyer requests to extend the settlement. So that's a bit different in that it's only usually the seller that can impose it. If the seller actually wants to extend settlement, the contract doesn't allow for that automatic penalty to be charged. I suppose the reasoning behind that is for a seller, they're obviously having to continue to pay mortgage, and therefore they're, you know, essentially on charging some type of penalty for that. Currently, the Queensland Law Society default contract rate is 10.61%, but that does change from time to time. So, as lawyers, we're constantly checking the Queensland Law Society website to see what that rate is, and if penalty interest is incurred, that will be as per that rate. Now, settlement can still mutually be agreed between both parties without the need to charge penalty interest. It's really at the seller's discretion whether they want to impose that or not. Now, I suppose, it's usually sometimes, we will have clients where the other side are coming to us, whether it be a seller or buyer, wanting to request settlement for, various different reasons. And, sometimes they're just asking for a settlement via this manner, so where it's mutually agreed. Often clients are not happy with that because then they know they could mutually agree to this extension and then use the further 5 business days. So, often clients are wanting to make sure that the other side, I suppose, use all the 5 business days that they can under the guaranteed extension, and then should they require further extension, our client then can mutually agree to that should they wish to, and obviously as a seller they can then impose that default penalty interest if they need. So moving on then from the settlement extension via mutual agreement. So how does the extension actually affect the settlement adjustment? So when I'm talking about settlement adjustments, I'm talking about adjustments to the purchase price. So you'll often have the purchase price less the deposit that the sellers, that the buyers paid for the purchase of the property, and then there's adjustments for things such as water rates. If it is a body corporate, the body corporate levies. Now that adjustment date is generally the actual settlement date, but notwithstanding any extensions of the settlement under clause 6.2, which is the mutually, not the mutually agreed, just the automatic extension. Adjustments are calculated based on the settlement date, including any extended settlement dates. However, if parties are extending settlement date by mutual agreement, often it may be a request, depending on who's going to benefit from the adjustment, that the settlement adjustments remain as at the original settlement date. So for example, if a buyer for whatever reason was not able to settle, they've extended by the normal 5 business days, and then they've asked for a further week, and that would therefore mean that the seller is paying rates for an extra week, they could request the adjustments remain at the settlement date, so that that cost is then on charged as well as penalty interest to the buyer. Now I'm going to move on to the deposit. So as I mentioned at the start, we often have clients that are a little bit unsure, how deposits work and, when they're payable and how much to pay, etc. So another amendment, I suppose, that come in, again, this has probably been about 2 years that it's been in place, was with the rise of electronic payments, there were changes made to those standard contract terms in the REQ contract and also the ADL form. So if a buyer effects an electronic transfer on or before the due date, they must provide written evidence that the electronic transfer has occurred. Often this is to the agent, and generally they'll also provide advice to the solicitor that's acting for them, and they do not take any steps to defer the payment, then the payment's actually considered as received on the day that the transfer was actually made. So often, as you know, with many banks, although you make a transfer today, sometimes it can take up to 2 business days. Often, there's things such as OSCO, which, means it's immediate for most banks and people making payments, but there is still those situation where it can take 2 business days. But as long as those 3 requirements, as I mentioned just now, are adhered to, the payment will be considered received on the day the transfer is made. And obviously the agent is generally the deposit holder and will confirm that once it's received in there and into their trust account. Now, that's in terms of, actually paying the deposit, but I suppose we probably should go the step before, what for a standard purchase is considered an actual reasonable deposit to put down. So it really does depend on the transaction and also the buyer and the seller. For a standard residential purchase though, it cannot be any more than 10%. However, if it is an off the plan purchase, and so for those not sure, off the plan essentially means that you're, as the name suggests, picking a property based on a proposed plan. So, often these are done for like vacant land where a developer's, taking a large parcel of land, developing it into smaller parcels that, a buyer then can build their, dream home on. Otherwise, the other most common off the plan one are apartment buildings. So again, there might be 100 townhouses or unit apartments that a developer is building, but obviously the buyer is purchasing them before sometimes construction's even started, and so they're purchasing based off marketing brochures and actual draft survey plan. Now for those types of purchases, the deposit can be a little bit higher, but it cannot exceed 20% of the purchase price. Now, deposits are often broken up as well into two payments. So the first one is known as the initial deposit. Now that's generally payable upon signing the contract. The other often one we normally tell clients is say within 2 business days, just to allow them time to make sure they actually get the signed contract on the date it was signed, and just to make sure that they can get that payment made. Now deposits, the initial deposits are generally the smaller amount between the two. It might only be a few $1,000s, a couple of $1,000s, just to show interest. With off the plan ones, that initial deposit's generally payable at the point of signing, like an expression of interest or an intent to purchase. The second deposit is the balance deposit. Now this usually becomes payable upon going unconditional. Now the term unconditional means once the contract has had all its conditions satisfied. So with the normal standard purchases, this is usually, it might be subject to generally the standard ones are just building and pest and finance. So once those 2 conditions are satisfied, balance deposit's usually payable, on that date or again within 2 business days. The balance deposit is generally the larger amount of the two, and that could be, as I mentioned before, anywhere up to 10%, but up to the buyer and seller as to what they want to put down and accept. If it's a $500,000 purchase, they might only be wanting to put down, $20,000 as the balance deposit with a $2,000 initial deposit. I suppose it's important to note though, these deposits, if the contract isn't unconditional, so if you're paying an initial deposit and the contract does, for whatever reason, get terminated under finance or building a pest or something like that, that deposit is generally, unless there's a special condition being drafted otherwise, fully refundable to the seller. Now the deposit is retained in the deposit holder's, I would always recommend it's an actual trust account, because there's certain trust accounting laws with both agents and lawyers where the deposit cannot be released to either party unless one's in breach of the contract. But generally the most common one is, as I mentioned, if it does terminate, but otherwise if it goes through to settlement, it's upon settlement. So if the agent's the deposit holder, general situation is at settlement, once it's all settled, both the buyer's solicitor and seller's solicitor will notify the agent, confirm it's settled, and then authorise both the release of that deposit to the actual seller, less the agent's commission, and then authorise obviously the release of the keys to the buyer. So that's essentially how deposits work in contracts and what happens. I suppose the other thing I didn't talk about is, there are these 2 payments. There are what's called instalment contracts, which come into play if a buyer, for whatever reason, starts paying, incremental payments for the purchase, which, generally we want to avoid because there are risks, and that's, kind of like a whole nother topic. But, there are, risks and things if we are paying above those 2 stipulated amounts, the 10% and 20%. All right, but otherwise that's essentially the main things that I wanted to talk about. So we've kind of covered off on the tenancy laws, how they've impacted upon the REOQ contracts, obviously the Property Law Act, when it's coming into play, what we can expect in terms of seller disclosure, what happens if we get contracts and there is no date included, but we've got, time records and things on the DocuSign records, talking about obviously deposits. So otherwise, by all means, feel free to reach out to me afterwards, and happy to set up a one-on-one chat and go through any of the upcoming changes that we can expect to receive over the coming months. But otherwise, thank you very much for everyone taking the time to join us today, and hopefully that's answered a few of the questions you may have that cross your mind in terms of those changes. So chat to you soon. Thank you, everyone. Thank you for tuning in to another episode of Property Powered Talks. We hope you found today's insights valuable and engaging. If you enjoyed the show, don't forget to subscribe and leave us a review. For more information or to connect with our expert team at NB Property Law, then please visit our website at noborderslawgroup.com.au. We look forward to having you join us next time for more expert advice and actionable strategies to master the world of property law. Until then, stay informed and stay empowered.